This is Vijayashri, working as an assistant professor at School of Law, Satyabama Institute of Science and Technology, deemed to be a university, Chennai, Tamil Nadu. Now we are going to learn about vicarious liability of master and servant under law of torts. Generally, in the field of law, if any person commit any wrongful or tortious act, that particular person will be liable for it, is act or omission. Whereas in vicarious liability, someone will be liable for the action and omission of some other person. So, from this itself it is very clear, it is an exception to the general rule of tortious liability. Consider a circumstance where A is liable to C for a injury or harm suffered by C by B. In this circumstance, A is not a part of a tort or not a tortfeasor, but still A is liable in this circumstance. Let us consider what are the requirements to be fulfilled to make A liable in this circumstance. First, there must be a wrongful act or tortious act. As such, C occurred by B. Second one is there must be a special relationship between a person alleged to be vicariously liable and the tortfeasor. That relationship might be master and servant, principal and agent, employer and employee, even parents and child. The third requirement is that it must be done, that is the tortious act must be done during the course of employment. These are all the requirements to be fulfilled to make A liable, that is vicariously liable under this circumstance. So, from this itself it is very clear. Vicarious liability is the concept that is an exception to the general rule of tortious liability. Vicarious liability is based on a principle Q facit per alium facit per se. The explanation to this maxim is that he who does any act through other person is deemed in law to be done by himself. That is, any person done any act through another person, he will be liable under the eye of law, not the person who commit that particular act. The next condition is that the wrongful act should be in the course of employment. These are the two conditions to be fulfilled basically under master and servant relationship in case of vicarious liability. Liabilities lies in respect of it is expressly or impliedly given by the employer. Second one is authorized work done in an wrongful way. Third one is unauthorized work itself given by the master to the servant. Under these three conditions, the master will be held liable under law of torts. First, we discuss about what is expressly or impliedly given by the master to the servant. In this case, we have to be very clear about the concept expressly prohibited. If any work is given by a master to the servant to do a certain work, where he expressed in a oral way or in an implied form of expression, that work to be done by the servant. In any case, if anything is expressly prohibited by the master, that is not to do certain thing by a master to the servant is not allowed to do that particular thing. For instance, if the master expressly prohibited certain acts not to be done by the servant, in case the servant done any act that is expressly prohibited by the master, in that case the master will not be liable. This is the effect of the term expressly prohibited in case of master and servant relationship. In all other situations, that is the circumstances, if any work is allotted to the servant, if it is done in any negligent form or any form of wrongful act, then the master will be liable. So, it is an exception whether it is expressly prohibited or not. If it is expressly prohibited, in that case the servant is liable, not the master. If a servant done any act negligently, that is breach of duty, if he omitted to do his duty properly, in that case the master is liable for the act done by his servant during his course of employment. It was well explained in a case law, Limpus versus London Omnibus and Company. In this case, the driver of the defendant's company to overtake another bus, he drive rashly and negligently. Due to this, the plaintiff met an accident. In this case law, the driver is authorized to do a certain act in an authorized way. but due to his negligence, he done it in a wrongful manner. Because of that, the plaintiff got injured. So, in this case, the master is liable for the negligent act of the servant. We discussed about the negligent act done by the servant, and master is liable to the negligent act of the servant in this particular case law. Now, we discuss about any fraud committed by the servant during this course of his employment. Any fraud or any theft or mistake committed by a servant, it is unknown to the master. In that case, whether master is liable to the fraud, theft or mistake done by the servant or not. It is well explained in a case law, Lloyd versus Gray Smith and Company. The master in this case is clearly unknown to that particular factor, but still this act is done during the course of employment. That is, the act of the wrongful act of the employee was done during the course of employment. So, here the master is made liable. Then in case of theft and fraud, for instance, if you are giving a cloth to a laundry, in a laundry shop, the person who is working in that particular shop steals or any of the cloth, then the laundry owner will be liable for us. The same way, if any mistake is done by the servant, the master will be held liable for the mistake done by the servant during the course of employment. In all above mentioned circumstances, we have mentioned clearly that whatever act done negligently, whether it is negligently, whether it is a theft or any fraud or mistake done by a servant during the course of employment will make the master liable. That is the vicarious liability. Then we consider another circumstances. In case a servant delegate his duty to another person and which is unknown to the master, whether in this circumstances whether the master is liable or not. If a servant has been authorized to do certain work by the master, in case of doing that work, the servant instead delegating his work to some other person, but it is unknown to the master. In this case, whether the master is liable or not. It is very well explained in a case law, Ricketts versus Thomson Tilling Limited. In this case, the driver has been authorized to drive the bus, but the driver feels tired and he asks the conductor to drive the bus. From this itself, it is very clear that it is not an authorized work given by the master to him, but still he delegating his work to the conductor. While the conductor driving the bus, negligently he hurt the pedestrian, so the plaintiff got injured. In this case, the court held that the master is liable. This is based on the principle of wrongful delegation. It is very conclusive in this case law. There is no any doubt to the court whether the master is liable or not, because it is based on the principle of wrongful delegation. Here the driver is not authorized to delegate his duty to the conductor, even it is knowingly or unknowingly to his master. Whatever might happen or whatever damage might happen to any person out of that wrongful delegation of his work, in that case the master will be liable. It is very conclusive. That is why in this case now the court held that the master is liable for the act done by his servant. I hope it is very clear when the master is made liable under law of torts. That is, we discussed about the condition, it must be charged. The person who is charged under this act is to be a servant. Second thing is the wrongful act or tortious act must be done during the course of employment. If these two conditions are fulfilled, then in that case the master will be liable under law of torts, that is vicariously liable. I hope you all enjoyed this session. Let we meet in another session with some other topic. Thank you.